Good morning, everybody. I'm very glad to be here today and join such an interesting conference concerning merger evaluation. First of all, I apologize on behalf of our chairman, Mr. Petruzzella, for not to be here today, but he's not allowed to participate to the conference because of an unexpected institutional duty, unfortunately not postponable. Secondly, let me thank Gianluca for the kind words used to introduce me, and thanks to Paolo for the organization of this meeting with a busy agenda, relevant topics, and very important speaker. Now I'm going to switch to Italian because I know the organization provides with an excellent service of translation, and I'm sure that it will allow our not Italian speaker colleagues to follow my speech. Così passo all'italiano. Allora, la sessione...
Today's session, this morning's session, is dedicated to past and future of merger control. Maybe our speakers have certain advantages because we can treat, generally speaking, policy in merger controls, talking about different subjects. I remember that one of the most important objectives of merger control is that of impede that through external growth we can create obstacles or borders to competition. And this can be done through a dominant position or coordinated effects or through with a dominant collective position. We have to discipline the different procedures and based on different procedures to be able to carry out merger control. I remember other objectives, maybe there are secondary objectives. We have to know the development of markets, and we have to intervene with more with stronger tools, where the authority and the commission apply the norms. The practice are not homogeneous. The EU Commission applies its guidelines, and the other state jurisdiction take care of other subjects. So we have to create a uniform application of antitrust principles, and we have a very complex referral system. I'm not going to go through this because you know this system very well. I just want to point out that in the years to have a homogeneous analysis of the referral system, the EU Commission has created some guidelines to guarantee the goal to have this harmonization. We have created a AGCM working group in 2010, and another group in November 2011 has approved the best practice in merger evaluation, which involves more member states. I think that we have to follow this path, and we have to implement this path, this avenue, in order to have an homogeneous solution, because we have a kind of web system, and when we have a web system, there is a risk to not to interpret well the system in this network. So we run the risk that we cannot understand this network. If all this is true, there is a need in the Italian legislation to adapt the Italian legislation to the EU merger regulation. We know that the Italian legislation differs from the EU merger regulation. The evaluation test of Article 6, Law 287, and the treatment for common firms. The Antitrust Commission the competition authority has requested a modification of this law 287, and as of you know, the test which was used by the Commission and presently by 20 state members out of 27 treats non-collusion situations also if there isn't a verification of the dominant position. The constitution of dominant positions versus substantial lessening of competition. It's a particularly useful tool to study mergers, especially in a period of economic recession, because they know that the merger analysis has to be very rigorous, and it's true that in the Italian legislation we don't have such a flexibility. We know that the Italian legislation, Article 6, Law 287, requires a law of the dominant position, whereas the EU test is more severe, is more strict. And on the other side, it is less strict because it bids the Commission to present, even in the presence of a dominant position, a hurdle or an obstacle to a real competition, an effective competition. So, and especially in a in a recession like this, the fact that this tool is lacking, it's a big problem for the Italian legislation. In the Italian legislation, we have requisites, the presence of the Italian economy, the full function, and the absence of coordination effects. Whereas the EU legislation comprise all the full function entities, and this creates a difference which creates obstacles to the normal referral procedures, and there is a difference of treatment between the national firms and the European firms. Since we have this need of harmonization, there is another big need of simplification. This simplification is felt on a national, European and Italian level. The optimization of the assessment of the merger has two objectives. One is to have a more efficient control using resources inside the authority. The second objective is the reduction bureaucratic burdens, and this is especially felt in this recession period. At European level, we know that last March the Commission has launched a public consultation, which just ended a few days ago, which aimed to simplify procedures of concentration of mergers. They had to broaden all the mergers, simplify or rationalize information requested in the official forms for notification, a reduction of 10%, and all these initiatives are and with the waning of these procedures, 56% of all the notifications should be 70%. The simplification of the official forms would allow to ask the parties to give more information, more important information, and identify relevant documents which are useful to estimate prices. I think this is all consistent with these needs. The authority, the national authorities and the Commission don't have to forget that the aim is not only to simplify the decision maker life, but also to reduce the bureaucratic burdens for firms who have to notify. So maybe on the notifiers have to look alternatives. They have to look for alternatives. Inside this need to simplify, in 2013, in Italian legislation appeared in there is something new. As you know that as of 1st of January 2013, the requisite regarding threshold, the cumulative thresholds, undertakes joint national turnover 482 millions and the target national turnover 48 millions. And for the reduction of notification, this requisite has been transformed into a cumulative requisite. They have to be both present, and they have to be, both thresholds have to be overcome, and this is due to different reasons. The willingness to have homogeneous procedures in the European at European level, and the modifications on the financing procedures of the authority. Once we have examined the financing system, which was based in the past on public funds and fees which were necessary for merger procedures, this eliminates the possibility to decrease the number of mergers and discouraged. This system of financing, this financing system of the authority multiplied the merger procedures in case of the new financing regime, which foresees that firms who overcome 50 million of income, has eliminated these risks, distortion risks, which and part of these fees ended up in all the effects in the first months of 2013. These are last data. In the first months, we have had 39 merger operations. There are some critical elements. One is thresholds are too high, also in comparison with the most important European countries, and then to overcome both thresholds are not appropriate, especially in Italy, where there are small and medium-sized firms. Now, talking about the European situation, all legislations foresee double threshold system. Maybe Spain has an alternative system of threshold, and UK we have a system of a voluntary and optional threshold. As far as the adequacy or appropriateness of threshold is concerned, the present system can create some consistency because the threshold of 48 million is okay if it's a big firm to be merged. More is the income of the firm which acquires, less has to be the income of the firm which has to be acquired. So the data that you can see in the table, I reported the data from 2013 of the previous system, and I've tried to verify what would have happened with the new system. Data I have collected, I have indicated before, indicates or shows that from the year 2000, 2013 have been 7,582 which have been notified. Only 17% of these procedures have been prohibited, and 0.4 have been cleared. All the proceedings have been 70% responded to the new requisites. So 70% wouldn't have been lost, and 20% of the total of the 47 proceedings has created prohibitions or conditional clearances. The authority is still acting in a very rigorous way. I think that there could be one problem, because even if you consider 30% or 20%, it's a pretty important data, and we have to examine it carefully. I think it's too early to get to conclusions. The authority is controlling and monitoring what is happening with the two thresholds, and I would exclude, considering that there are alternative paths. I think that other tools like a different use of the dominant position so don't really respond to the needs of the merger control, and I doubt that Article 22 of the European legislation, which has been mentioned by Beatrice, could be used to supply a minor control of situations. We know that the Article 22 was born as a Dutch clause, but also the public consultation and the Commission just opened on the modification of the norm of the proceedings of merger, and the presence of the Article 22, which is considered as the best placed authority. So I don't think that the Dutch clause could be transformed into the Italian clause because there has been modifications of the thresholds. I think there has to be monitoring and also some modification to those data that I have given you before. We could add lost operations which have brought to prohibition, and 11 cases out of 14 the target was lower, but upper than 5%. So to overcome this threshold would help, so we can recuperate 20% of the total of the operations. I don't want to say that this is the best solution. I just want to give you an example on how we can conjugate the maintenance, how to keep the simplification needs and the need of a verification of how to respond to the threshold need. So now I'm talking about two different questions. The manuality shareholdings. The praxis of the Italian authority is to, as far as the minor stakeholdings are estimated. We know this de facto control is not easy to demonstrate. We know there are some indicators, parasocial agreement, shifting majorities. We know that it's not easy to tackle in a litigious situation. In areas where the problem of the minor shareholdings merger is more evident, we have the interlocking directories praxis. Okay. The economic theory have identified two different effects, the unilateral effects which bring to a reduction of the coordinated effects. The information exchange should be easy with the collusive subjects. I forgot to show you the slides. We have more coordination effects. We know that in our regime there has been a change of the Article a change of the Article 37 of the Article 214, which credit, insurance, and financial area. They have examined a group of competitive firms. Now, the problem of minority shareholdings, this problem has been treated in a different way by different legislation. Germany, Austria, and UK, they expressly treated this law. The new member state, Norway, has never applied a new system. Now there are, we can follow different paths to assess the minority shareholdings thanks to agreement, or to subject minority shareholdings to notification, to compulsory notification or optional notification. The Italian authority hasn't a clear position, is following very carefully the debates which arose on European level. I don't want to have situations which made which can make the tools too stiff. I also wanted to speak about remedies before I conclude my presentation. Is an old history. The authority knows that the effectiveness of the remedies and the respect of the proportionality principles. We have structural remedies, behavioral remedies. The structural remedies are easier to be controlled ex post. I would like to underline the difference of remedies. We often use undertaking, the term undertaking, not in a proper way, in the sense that the measures proposed by the firms in the notification phase or in phase number 1 are different from those proposed in phase 2. They differ because those measures are part of as an element of the operation. So the operation passes to phase 1 thanks to those measures. And those measures are constitutional elements. Without those measures, the operation is not possible. Operation with different situation would create a new compulsory notification. This can be found in the Italian legislation. And the fine would be because new operations have not been notified. Why? Measures proposed by firms and the authority welcomes in the adopts. Those measures are prescription of the clearance, whose violation would have much more relevant results and would create a fine to 1%, from 1% to 10% of the income of the. This threshold of 1% is a leftover of the old system of how to calculate fines, and would be too high for valuations which, yes, exist but are not so important, but may discourage the authority to open binding operations, because we will go towards a minor fine, which would be really too high. So maybe that's why we have to reason, and we have to talk about a change of the norm. Another important point in terms of remedies, and is to go too far beyond the borders. It's true that the judge, maybe this is because I've been working on this for many years, and I remember many cases like Infostrada and Eni. There has been adopted a measure, and the Italian antitrust had proposed to the parliament, but wouldn't foresee the liberalization of the electricity. Going towards the conclusions, I think that the past and the future of merger control have a European or ex-European dimension, and although the legislations are different among them, I think that the need of uniformity and to be homogeneous is very important, along with the needs of simplification that I've mentioned. We have to do a big work. We still have a lot of workload to do, even though there has to be an economic analysis, but we have to avoid the risk to not to consider in a general way all the problems. We have to protect the Italian national samples, and we don't have to talk too much about national problems. Guido Rossi has said that Pitofsky has considered the political intent of antitrust, which is the main source of legitimation of any norm, and not only of antitrust. Personally, the term political content of antitrust, I don't like it very much, but we have to be aware of the political content of the decision in terms of merger controls. And this awareness, even if we go beyond the European borders, I would like to remind that the Chinese law on merger, prohibition and merger acquisition, domestic enterprise by a foreign investor, regulates mergers, national mergers from foreign acquirers. The fact that we are very far from the Chinese legislation doesn't mean that we have to lessen our efforts to improve our legislation. And I think that today's conference is aimed to do this effort, and that's why I repeat that I congratulate again with the organizers of this conference.